So good afternoon, everybody. We're going to go ahead and get started. Welcome to the webinar, Understanding Trusts, which is brought to you by AARP. My name is Elizabeth Aloni, and I'm with Schneps Media. We are the largest media outlet, local media outlet in New York. We have over 80 newspapers, webinars, magazines, websites, podcasts, and events throughout Queens, Brooklyn, the Bronx, Manhattan, Westchester, Long Island, and Philadelphia. Today, I'm thrilled to be able to bring to you, along with AARP New York, Understanding Trust with Ron Fatoullah. I'd like to introduce to you Antonio Coppola, who is the Associate State Director of New York City for AARP. Welcome, Antonio.
Thank you so much, and greetings, everyone. On behalf of AARP New York, I would like to welcome you all to the Understanding Trusts webinar. My name is Antonio Coppola. I'm the Associate State Director for Community Engagement for AARP here in New York City. AARP is the nation's largest nonprofit, nonpartisan organization dedicated to empowering Americans 50 and older to choose how they live as they age. AARP works to strengthen communities and advocate for what matters most to families, with a focus on health, security, financial stability, and personal fulfillment. In today's uncertain economy, planning for your future, for your financial future, is more important than ever. And that is why AARP New York is proud to sponsor Schneps Media's 3-part webinar series on financial wellness, to give you the information and tools you need to protect yourselves and your assets during these uncertain times. The webinars will cover a wide range of topics, such as how to prevent the necessity for a guardianship action, things you need to know now about new community Medicaid laws, and understanding estate planning. So thank you so much for joining today's Understanding Trusts webinar.
Thank you so much, Antonio. And this is the third of the 3-part series, and you are able to see the first 2 parts, both on the Schneps Media YouTube channel, as well as on AARP New York and AARP Long Island Facebook pages. So if you missed those, you can certainly see them, and you will be able to see this one again and share this one as well. So I just wanted to let you know that before we get started. But it is my absolute pleasure to be able to introduce the top elder law attorney from Ronald Fatoullah and Associates, Ron Fatoullah himself. Welcome, Ron. You just need to unmute yourself, Ron.
Minor issue, right?
We all do it.
Yeah, we all do that at least once. So here we are. Thank you so much, Elizabeth. I appreciate it. And thank you, Antonio. And I think both you and everybody who's listening to this know how much I appreciate Schneps Media for everything that you've done. You get out so much information, especially now during the pandemic, to so many people locally, what people need to hear. And AARP, what a great organization. I was on the executive council for AARP for 5 years. It was an amazing stint. So thank you guys so much. So, being in my own practice, doing elder law and estate planning, one of the question that everyone asks, do I need a trust? Or sometimes they actually just call me and say, I want a trust. And so I'm going to go over trust in detail. And I'm going to share slides. I do have slides right here. Here we go. So the presentation will be Understanding Trust. Now, this is my contact information if anybody wants to know. The funny last spelling of my last name there, etc. So many people want to know, do I need a trust? But many times people don't even know what a trust is. And so many of you heard me already lecture about Medicaid trusts and Medicaid this and Medicaid that. And I'm going to touch upon that. But my main focus today will be talking about trusts holistically. There are so many reasons to have a trust, but not everybody needs a trust. And the other question that I have is, and I get all the time, well, I have a will. Do I need a trust? So I'm going to touch upon wills as well today. And, at first I was thinking, maybe there should be wills versus trusts, but this is not a contest. So really, the conversation will be, what does a will do? Why should I have a will? But why should I also have a trust? So let's get going. And what I find astounding is that so many people say to me, Ron, I heard you talk about a trust, or my friend had a trust that your firm drafted. Everything worked out well. They preserved assets, or they got on Medicaid, or they saved on estate taxes, etc. I want one. Well, it's not one size fits all. But what I really, I find astounding is that many people who tell me they want a trust, and I would ask, well, why? Do you even know what a trust is? And many times they say, not really. So let's take it from the beginning, which is where we need to start today. So what is a trust? A trust is an agreement that's entered into by an individual that creates the trust with the help of the attorney. That individual who creates the trust, look at bullet point number 2, is called the grantor or the settlor or the creator of the trust. So the grantor enters into a trust agreement and sets forth all the rules of that trust instrument. Now that trust instrument creates an entity called a trust. And that entity holds assets. And those assets are managed by the trustee of the trust, who can also be the grantor. You might create the trust, and depending on the type of trust, you might also be the trustee. So a trust is simply an agreement that's created by an individual called the grantor, settlor, or creator. So it creates an agreement to be signed also by an individual who's going to be managing assets held by the trust for the benefit of certain individuals. Now, it might seem a little counterintuitive, but the individual that creates the trust, the grantor, and the individual that manages the trust, the trustee, and the beneficiaries can all be the same person. I could create a revocable trust for myself, and I could be the trustee of that trust, and I could get a benefit from that trust. I could get all of the income, or I could get some of the principal as well. But when I pass away, I set forth where those assets go when I pass away in detail, without probate, etc. So we're going to be talking about different types of trusts, when to do a trust, when not to do a trust, etc. So that's what a trust is: an agreement that creates an entity that holds assets that are managed in a very precise way for a specific purpose. It might be to protect assets for Medicaid purposes. It might be to protect assets for a pet. That's a pet trust. It might be to avoid probate. It might be because maybe there might be creditor issues, in the future. It might be because you have a special needs child. The list goes on, and we're going to be talking about this. But that's what a trust is. So a trust is created for a purpose, and assets have to be transferred into that trust for it to be managed by the trust. I could create the best trust in the world, but if it's not funded with assets, it's a worthless piece of paper. We could work so hard on it, but assets must be funded, assets must be transferred into the trust. The trust must be funded for it to control those assets. So please remember that. I see that with many of my colleagues. Other individuals come to us many times, after hearing a lecture like this, or just for a second opinion. And, they have this trust, but it's never funded. If you don't fund the trust is worthless, So just remember that. So now you know what a trust is. So there are two basic types of trust. Look at the third bullet point. One is a living trust. That is a trust that's signed right now while you're living, when it's signed by the grantor, the creator of the trust, and the trustee. That's when it's effective. And that's a living trust. It's signed now while you're living, and it's effective right when it's signed by the parties, right now. Then what's a testamentary trust? That's a trust that's put into a will, into your last will and testament. Now, that trust is not effective until the will gets probated. It's not a bad thing, but it gives you a hint as to why the living trust, or we call it the inter vivos trust, is typically much better than a trust within the will. But depending on the circumstances, there's a reason why we do one as opposed to another. So we have a living trust signed right now while you're living, or a testamentary trust, a trust that's drafted in its entirety and put into your will that will become effective after death and after the will is probated. Okay, and that's explained in the fourth bullet point. Now, with living trusts, there are two basic categories of living trusts. If you look at the fifth bullet point, we have revocable living trusts and we have irrevocable living trusts. And they're created for so many different reasons. A revocable living trust is a living trust that is signed right here, right now. It's good while you're living, but it's revocable. You can change it anytime. You could modify it. You could revoke it, terminate it, do whatever you want with it. And that's fine. Or we have an irrevocable trust. That trust is stated to be irrevocable. And you can't revoke it unless you get the consent of the grantor, the creator, the trustee, and if the individual, the attorney who creates the trust, isn't creative enough, you may need all the beneficiaries. But we draft our irrevocable trusts to make them, and I know again it's going to sound a bit crazy, but we draft our irrevocable trusts to make it easier for the grantor to revoke that irrevocable trust. So sometimes that has to be done with the consent of the grantor and the trustee. But there's a section in a law, States Powers and Trust Law 7-1.9, that talks about revoking irrevocable trusts as well. So we have revocable trusts and we have irrevocable trusts. If a trust is drafted and nothing is said by the attorney, although something should be said, but if nothing is said, a trust is deemed to be irrevocable. And again, that's counterintuitive. When I polled many people, they said, well, if you don't put anything in, of course it's revocable. It's deemed to be irrevocable unless stated otherwise. Okay. Now, the next bullet point, I stated very carefully and clearly, a revocable trust can be revoked or modified no matter what. An irrevocable trust can also be revoked or modified under certain circumstances. And that's why you need the attorney to be very careful on how that irrevocable trust is to be drafted. Okay. When you have a trust in a will, that trust is inherently irrevocable, because in order to revoke a trust, you need the consent of the grantor. But with that trust within the will, well, the grantor is gone, is deceased. So if that grantor is dead, you can't get the consent of the grantor anymore. So the testamentary trust is inherently an irrevocable trust. Now, the last bullet point is just so important, because so many of you heard me talk about Medicaid trusts, Medicaid trusts. They're very important, especially now in light of the new Medicaid changes, which provide for a waiting period for Medicaid home care starting April 1. And you guys, we spoke about that last time. There's a window of opportunity to get Medicaid applications in now and not have a look back. But applications in after April 1 will have and incur a 30-month look back. So be careful. But how do we protect assets in light of the look back for Medicaid home care? And we've always had the 5-year look back for Medicaid nursing home care. The best way to protect those assets is with a Medicaid irrevocable asset protection trust. But now I want to talk about wills. Now, I touched upon wills a couple of sessions ago, but I'm just going to spend a couple of minutes on wills and trusts. And again, if you look at I think it's the 6th or 7th bullet point, it's not wills versus trusts. It's trust and wills. Even if you have a living trust and it's drafted impeccably and it works impeccably, you want a will as a catch-all. You know, there might be an asset that you don't have controlled by the living trust. Maybe it's a diamond engagement ring give to a daughter or whatnot. Or it might be an asset that you forgot to put in and forgot to fund the trust with. So you want the will. So it's not wills versus trust, as many people think. It's get a great trust. Make sure it works 1,000% for what you want it to. Protect assets for Medicaid planning, avoiding probate, creditor issues. I mean, the list goes on and on. I'm going to be talking about lots of these issues, but have a catch-all. You need the will also. So what is a will? A will sets forth where assets go when you pass away, but not all assets. Only assets that don't have a beneficiary designation and assets that are not a part of a trust, not a part of a living trust. So if you have assets in a trust, the will won't control those assets. And there are so many advantages to that. When you have a last will and testament, we do have what we call specific bequests, and we have a residuary. Specific bequests, and that's a term of art, specific bequests are certain assets that are given specifically. It's not a catch-all. So you might say my diamond engagement ring to my daughter. You might say my property located in, let's say, Queens, New York, to my son. You have to be more specific than that, but you might say that. That's a specific bequest where a specific property goes to a specific individual or individuals. And then you have this catch-all, the residuary clause, and that's for everything else. You know, you might say everything equally to my 3 children, or 10% to my grandchildren, and the rest equally to my children. You remember in a trust, we had the grantor, the trustee, and the beneficiaries. In the will, look at the fourth bullet point, we have the testator. Female is a testatrix. The testator is the individual that signs the will. It's your will. You're the testator. It's the executor who manages the assets after death. Whereas in the trust, you could be the grantor and the trustee. In your will, sorry guys, you need an executor, and it can't be you, because the will sets forth where your assets go after you pass away. So somebody else has to be the executor. And you definitely want to name a successor executor. The female executor is called an executrix. And then we have beneficiaries. Who's going to get? Will the individual in the will get outright? Will it go, the certain amount go to individuals? It could go to a charity. It could go to an entity, or it could go to the testamentary trust, the trust within the will that I spoke about earlier. Now, many times clients come to me and say, well, I know I can't control from the grave. I say, no, you can control from the grave. You can. That's what a trust does. If you have a living trust, it could survive the time when you pass away. It could survive your demise and control how those assets are doled out after you're gone. Same thing with the testamentary trust. You can control from the grave. Not everything, but you can control how your assets are doled out. Probably not good for certain clients. They don't need that. But for certain other clients, it might be a godsend. And we're going to talk about that. So let's say you have this will and you have this trust. If the trust has all of the assets in it, the will is just a catch-all just in case something is not in the trust or there's no beneficiary designation. So if there's nothing that the will controls, you don't have to probate the will. But, if you don't have a trust and you don't have beneficiary designations, then those assets are controlled by the will, and the will has to go through the probate process. And, there's a petition, there's court supervision on everything. An individual has the right to contest a will, and distributees, individuals who would get if there were no will, like a spouse and children, etc., can contest. Even if a child is estranged, can contest the will. That's another reason why living trusts are a much better way to go. Now, you can look at the second to last bullet point. In your will, you can actually leave instructions as to whom you wish to be the guardian of your minor children, if you have minor children. And with a will, once it's been admitted to probate, you can't contest it. But just think about it. The distributees get a notice in writing saying, if you have a problem with this will, come to court, the surrogate's court, on so-and-so date, and you could contest the will. So it's right there in black and white. So if it's an issue where you're concerned, I would say, let's definitely go with a living trust as opposed to a last will and testament if you think the will might be contested. And if you think a will might be contested, there are so many techniques that we can use to lessen and virtually eliminate the chance of a will contest. So look, living trusts are absolutely amazing. It's just wonderful. but there are some pros to a will as well. So with a will, there's no need to retitle the assets into the trust because you don't have a trust. With a living trust, you need to retitle the assets into the name of the trustee of the living trust. But with a will, you don't need to do that. But then on the other hand, it has to go through probate, there's court supervision, and the court, overlooks everything. Now, probate is not a dirty word. Probate could be good if you're really concerned about questionable family members that might serve as administrators or even executors of your will. Let a court look at everything to make sure that everything is done the right way. But barring that, a trust is so much better than just having a living will. But the absolute best would be to have your trust, your living trust, and the will as a catch-all. A testator under the will, again, could leave instructions on guardianships, and then you don't have as many statute of limitation issues with the will, but on the other hand, it's much likely to be contested. But what are the cons of a will? Well, biggest con, and so many people set up trusts to avoid probate, because probate is costly and it's time consuming. And look at the first bullet point. Assets typically are not distributed for at least 7 months after we get letters testamentary, letters to the executor saying, well, now you could act. It typically takes a while. Now think about it. That's a long time. What if you had within that will a special needs trust and you couldn't get assets distributed, for a while? Well, we could try to get expedited letters testamentary, but it's still a much, much, much slower process than having assets in a trust where you don't have to wait at all. We have the trust, individual dies. If there's a special needs trust within that living trust, let's say for a disabled child, well, immediately those assets are there for that child. You don't have to wait. Okay. Another con, which we went into, it's easier to contest a will than a trust because you get that notice. You want to contest, come to court, the surrogate's court on so-and-so date. Okay. So we have that. Also, if you have real estate, look at the fourth bullet point, so important. Real estate outside of New York State, like a condo in Florida, or a place in the Poconos or whatnot. And lately, we're dealing with a lot of clients who might have bought something like that. Believe it or not, you're going to have to probate in New York and then probate in Florida or the other state that has the real estate. And that's called ancillary probate. 2 probates? 1 is certainly more than enough. To have 2 would be crazy. So you want the attorney, such as myself or my firm, to handle that and create a trust and transfer the property in New York and Florida or Pennsylvania, where you might have a second home, into that trust to avoid not only probate in New York, but probate in that other state. What are some of the other cons of a will? Well, a will is a public document. And I remember, I felt so badly after John Lennon passed away. And people were talking about, well, just Google John Lennon's will. I said, no way, you can't do that. But you can. A will is a public document. And if privacy is a concern, a living trust certainly is a better way to go. And not only the will, but probate also contains information about the individual who passed away. Could be you or me, the executor, the family's contact information. Everything is public. Bullet point number 2, if a will is lost, it's presumed to be revoked unless the attorney keeps the original will. That's why we do that. If a client wants us to, we do that as a courtesy to our client, for no charge. But you got to be careful. You got to be careful. An executor has to perform his or her duties with due diligence and has to notify distributees, those individuals who would get if there were no will. And if you don't have a clean family tree, you have distant relatives, let's say you don't have a spouse or children or parents or siblings, well, that's when, you're going to have big problems with a will as opposed to a trust, because we have to go over that family tree in the surrogate's court, and with distant relatives who you probably may not want to give to in any event, those individuals would get your property, and it makes it so difficult for the attorneys, for us, when we do that probate work, to get that family tree down and locate everyone. So be careful. You do want to get your family tree set. When you have a will and assets might go to a minor, or there's a minor child or a disabled distributee, the court appoints a guardian ad litem. Look at that term in the last bullet point. A guardian ad litem is required to protect the minor or disabled individual distributee that may not have his or her own voice, but it's a requirement. What are the pros of a trust? Well, we can avoid probate, okay? The assets can be held outside of the trust and still avoid probate for everything within the trust. But it's better to have most assets held in the trust, but not retirement accounts. Don't let the trust hold retirement accounts. If we have time, I'm going to get into that. A trust could be the beneficiary of a retirement account, but don't transfer an IRA into a trust, because an IRA is an individual retirement account, and you're going to owe Uncle Sam in New York State a bunch of money if you transfer that IRA ownership to a living trust. So don't do that. Let's look at the second big bullet point. The distribution of assets in a trust happens right away. We don't have to wait. But when we do have assets in a trust, what we do recommend and what we do for our clients, we do what we call trust administration. We prepare an informal accounting, so nobody's going to have a question about what the trustee did and didn't do. Number one, we prepare receipts and releases and a refunding agreement to make sure that the beneficiary is going to get those assets. They're going to release the trustee. And we'll also say that should there be a mistake, but there shouldn't be, but if, God forbid, there is a mistake, then the individual agrees to refund any items that were distributed in error. So that's further protection for the trustee. Assets held in a trust are not public records. Everything is private, okay? The only exception is when there's a judicial accounting, when the court says, you have to settle this trust, and we, the court, are going to look over everything. That typically doesn't happen. Out-of-state property, if it's not in the trust, you're gonna have to probate that too. So the fourth bullet point, living trusts are effective during the lifetime of the creator of the trust, the grantor. And the grantor talks about instructions, even for themselves. Let's say we do a revocable trust for an individual. Yes, it's great that it avoids probate, but it's great to have that trust. God forbid if the individual becomes incapacitated, everything is held under one roof. It's clear. And the successor trustee that you handpick would step right in and manage those assets just the way you want them. So a living trust is there for your lifetime, and it protects you even upon incapacity. And as a grantor, depending on the type of trust, you could manage the assets in that trust. And of course, it's much, much harder to contest. Are there any cons to a trust? Not really. But one con is that you have to transfer the assets into the trust for it to be held by the trust. But once you do that, then you're done. They're held by the trust. They could be protected for Medicaid. You could avoid probate. For so many other reasons, you've got it. And everything is just fine. Okay. Now, what about capacity? In order to have capacity to sign a will, you have to understand the extent and value of your property. Who would typically get? You have to know who's in your family. And you have to understand the nature and consequences of signing the will. Okay, not a really high threshold. Okay, now a trust, the grantor of a trust has to understand the nature and consequences of signing the trust. And the testator, the grantor of the trust, must be 18 years of age or older to create the trust or create his or her last will and testament. Sometimes there's an issue of undue influence. That's when it could be a family member or a third party influences someone, pressures someone to sign the trust or sign the will. If that happens, then sometimes we could overturn that trust. But you need to be lucid when you sign these documents. So the sooner you sign them, the better these documents are going to be. But if you wait too long and you don't have capacity, then you can't sign these documents, unfortunately. Okay. Again, I said this a couple of sessions ago, we can virtually sign this trust, witness this trust, or get it notarized. And we could do all of this in the comfort of your living room, witnessed in the comfort of your living room, and you could be there alone. Witnesses could be there virtually, and we could notarize this and witness this, and we'll have no issues. Just briefly, I'm only going to talk a couple of minutes about the Medicaid Asset Protection Trust, but the trust has to be irrevocable. But now you know we could, if we have to, revoke that irrevocable trust with the consent of the grantor and the trustee, the way we draft our trust. The grantor, the creator of the trust, typically in a Medicaid trust, should not be the trustee, just for that type of trust. And principal should not be given to the grantor settlor. Income can be, but not the principal. So you got to be careful. Now, for Medicaid trust, what properties are good to put in the trust? Well, your home, your condo, your co-op, because you have the ability to live in it. You could get the rental income if you want. If it's sold, you get the $250,000 exclusion from capital gains. It's great. If you're married, you get $500,000. The asset is included in your, not in your probatable estate. It won't be probated, but you get the basis step up. How great is that? So the asset is out for Medicaid, but you get all the tax benefit as if the asset were actually in your name, but it's not in your name. It's wonderful. And you also maintain control, even though it's an irrevocable trust, because you have a limited power of appointment. You could say, well, I don't want to give as much to my son or my daughter. You want to change it. You can always change it. So you have this degree of control and independence. And Medicaid trusts are good also for brokerage accounts, any accounts or real property that you bought a while ago, or their capital gains, because you get a basis step up later on where your estate doesn't have to pay any capital gains. How amazing is that? Protecting assets for Medicaid purposes, getting a basis step up where there will be zero capital gains taxes. You get to $250,000 exclusion from capital gains tax if you sell your home, or $500,000 if you have a spouse, and you can get all the income. How terrific is that? Okay, so you have all of these advantages that I went through, and you do have a certain degree of control. Now, for the next few minutes, I want to talk about other types of trusts. Now, if you want to give assets to someone that has a special needs, a disabled individual, you can do that with a special needs trust. So we could actually create a living trust for you. You can have all of the benefits of that living trust, but also say, I give 1/3, let's say you have 3 children, a third outright to child A, a third outright to child B, but to my child with special needs, I give 1/3 to the trustee of that special needs trust. What benefit is that? The benefit is huge, because that child with special needs can stay on Medicaid, can stay on SSI, and these funds can be used as a war chest to pay for whatever they would need, virtually whatever they would need. So let's say they wanted to get a mattress from Mattress Firm. The trustee of that special needs trust won't give the money to the child, but we'll just say, well, this mattress is $2,000. So we'll buy it and we'll deliver it to the special needs child that you have. So it's a wonderful thing. Let's look at that first bullet point. I'm talking about a third-party special needs trust where you are not disabled, but you want to give to a child or someone else who is disabled. That's a third-party special needs trust. First-party special needs trust is where, let's say you have someone with special needs and there's a negligence claim or malpractice suit, and that child gets $2 million and they're on Medicaid. We could create a first-party trust if they're under 65 and preserve those assets. That's federal law that enables this. But when the individual dies, only with the first-party trust. When the individual dies, then Medicaid is paid back. But if you're going to provide for someone else, Medicaid never gets paid back. All the assets are preserved for you and your family. So special needs trusts are a very important reason why we do trusts. Spendthrift trusts. I hear this all the time. You know, you love your children, but what do I hear a lot? I love my son, I love my daughter, but I don't know about my daughter-in-law or my son-in-law. It's the in-laws. And many of my clients call them the outlaws. What are you going to do? So if there's an issue with a child that you want to provide for, or a third party, or anyone you want to provide for, we can create a spendthrift trust. Within the trust that we create for you, we could have a special needs trust, we could have a spendthrift trust, where let's say 1/3 to child A outright, there are no issues. 1/3 to child B outright, no issues. But to child C is not disabled, but child C can't manage money. There's an issue. Or maybe child C has an addiction. That's a problem. So we could create a spendthrift trust, another reason to create a trust where those assets for the protection of that child or beneficiary will be doled out any which way you want. Be over their lifetime, over a period of years. They could get all the income, they could get part of the income and part of the principal, but we go over this in detail with you to protect the asset from a beneficiary who might sabotage their own inheritance. Maybe because they just can't manage money well, or maybe because, they have an addiction or some other issue. Now, we do trusts for estate tax planning all the time. Right now, the federal estate tax level, starting January 1, is $11.7 million. But Joe Biden wants to bring that down to $3.5 million. We'll see what happens. But we do trusts to protect assets all the time from estate taxes. New York State's level is $5.85 million in 2020. The 2021 figure hasn't been published yet, but likely will go up slightly. We don't have time to go into all of the intricacies, but we could make this slide deck available for you. But one of the mechanisms that we use quite often is, would be a disclaimer, credit shelter, or exclusion trust. And in this way, we could make sure that we're using the New York State freebie, close to $6 million for both spouses when the couple has, has a large amount of money. So we do trusts for estate tax purposes all the time. Pet trusts. I did a webinar on pet trusts just a couple of weeks ago, and we love our pooches, right? And you may want to create a trust, and it's governed by Estates, Powers, and Trust Law in New York State, 7-8.1. I thought I'd paraphrase the law, but you can allocate a certain amount of money to be put in trust, again, within that same living trust that we draft for you. A certain amount of money for your pet, and you can have someone else take care of it, but they don't have to worry about coming out of pocket. And you set forth what you want, what you don't want. Do you want doggy daycare? Do you not want doggy daycare? How often do you want your pet to be groomed, etc.? You could say it all in your pet trust. And you could take a look at this later on. For second marriages, we have another type of trust. You may be let's say, more well-to-do spouse, and you want to provide for your second or third spouse, but you also want to provide for your children and save on estate taxes. We might do a so-called Q-tip trust. It's called a Qualified Terminable Interest Property Trust, where the surviving spouse can't control the principal of the trust, but will get the income. And then when she dies, the assets could go to your children from your first marriage. There are charitable trusts. We have charitable remainder trusts. As you see, it allows the beneficiary to receive income, and a charity gets the principal later on, let's say when you pass away. Or a charitable lead trust, where the charity gets the income and the family gets the assets later on. But it's a way to get a deduction and do a great thing. So we have charitable trusts. Now, you remember before I said, don't make your retirement account, don't transfer that retirement account into your living trust. That's true. But you can make a trust the beneficiary of a retirement account. Okay, so please understand the difference. Don't transfer ownership to a living trust. That would, make all of that money taxable, but you can make the trust the beneficiary of a retirement account. If you have an estate of $50,000 or less, it doesn't have to go through full-blown probate. Just want you to know there is a small estate administration proceeding that you can do. And just some things to consider. If you have current creditors, it's going to be very difficult to protect those assets, but you want to be proactive and create a trust before you have creditors. Okay. But if you set up that irrevocable trust when you don't have creditors knocking on your door, because that would be a fraudulent conveyance, you can protect assets from creditors. Okay. So that's my presentation on understanding trusts. Here's my contact information. The firm is Ronald Fatoullah Associates, and we have offices in New York City and Long Island, and we'd be happy to help anyone. And I'm more than happy to take any questions that you guys have at this point in time. So let me stop sharing this.
Thank you, Ron. That was fantastic. What incredible information. And we certainly do have a lot of questions. So I'm going to try and get to a few of them.
Oh my God, over 20 questions. Okay.
I won't give you all of them, but we'll do our best to get to as many.
Elizabeth, you pick and choose. It's fine.
So Diana wanted to know, what recommendations can you offer if there's not a family member or an immediate person to name as an estate trustee?
Well, you're going to need a trustee. So I would go with a friend. You may even want to name an accountant or sometimes an attorney. I mean, we typically don't like to be trustees of the trust, but you can, if it's the only way to go, you could name someone that you're close with, like a financial advisor, an accountant, or possibly an attorney. But, let the attorney be a lawyer and let somebody else be the trustee.
Great, thank you. Christine wants to know, does her husband have rights to their minor child's trust if they're legally separated?
If you set up the trust and it's with your money, your husband, who you legally separated from, should not have control over those monies, because it's your money and you created the trust. But if they're both your children, he will have a say in the upbringing of those children.
Great, thank you. We have another question around children. Frank wants to know, what happens if you leave a guardian for your child in your will? Do you have to wait for probate? And what happens with the child between the date of death and probate?
Very good question.
That's a great
so you should know that the will is a form to put down who you want to name as a guardian. But the court will look at that and they will actually, let's say you named as a guardian, sorry, I'm going to use an awful example, a child molester. The court, even though you put that in, sorry, I see your eyebrows raised, Antonio. Sorry for the extreme example, but just by way of example, a court is no way going to let that individual be the guardian. So the court's just not simply going to follow whatever you want, but barring an extreme example, boy, that was too extreme of an example. Sorry about that, guys. But barring an extreme situation, a court will listen to what you have in a will. The will should be probated, but we can get expedited letters of testamentary pretty quickly.
Yeah, I could see how that could be a concern when you have small children.
Oh, absolutely. Sorry for the bad example. I shouldn't.
No. Look, I mean, I think it's an important point that that the court is going to make sure the children are safe.
Exactly.
And these are different things that, when you sit with an attorney, are some of these things that you talk about, of the what ifs and the scenarios that may or may not happen, but there's something to think about as you're making these decisions. So
Exactly.
I appreciate that.
Right.
Mary wants to know, does a single person without any children need a trust? I have shares of a house my parents left to their children, and I'd like to leave my share to another family member. Should I pass first? Do I need a trust for this?
Okay, nobody needs a trust. A trust is there for a certain reason. If you have no spouse and no children, I think a trust is just as important because, you know, you have distant family members and you would want that to go without probate. So I personally think, not knowing all of the nitty-gritty details of your case, probably a very good idea to have a living trust, especially when you don't have close family members.
Great, thank you for that. Celeste wants to know, what conditions cause a will to have to go through probate?
Okay, you know, I'm smiling because, you know, when you have assets that are not in a trust and they don't have any beneficiary designations, the will controls. But for the will to control, the will has to go through the probate process. And the probate process provides that you take the original will, we give it to the surrogate's court, we sign a petition, have the executor sign a petition, we get all distributees, you know, like children or spouse, to sign off on it. We have to go through the probate process if you have a will. So the will won't have teeth unless it goes to probate, but we don't want the will to control. That's why we like a trust. But if a will is going to control because you don't have a trust and don't have beneficiaries designated, then the will need to go through the probate process.
Thank you. Harriet wants to know, who can contest a will, and is there a time limit to contest a will?
Okay. Who can contest the will? Yes. Anyone who is named as a beneficiary, sorry, let me scratch that for a second. Anyone who's a distributee, who would get if there were no will. Now, when I spoke in the first session about wills, I spoke about who would get if there were no will. You know, like a spouse and children, they could contest. If there's no spouse and no children, parents, well, they could contest. If there's no spouse, no children, and parents, siblings could contest. So who would get if there were no will can contest. And those individuals are called distributees.
So do they have to be named in the will to be able to contest it, or no?
Nope, no, not at all.
Okay.
Just have to be distributees.
Okay. So Leonard would like, thank you for that. Leonard would like to know, can a beneficiary to a will also be the executor?
Yes. Yeah. And when you think about it, let's say you only have one child and you want to give everything to that child. That child could be the executor and could be a beneficiary and get all your assets. Absolutely, no doubt. Okay. Same thing, that child could be a trustee and also a beneficiary of a trust in the same way.
Terrific, terrific. Alice wants to know, you had said that the retirement account should not go into a trust, but what assets have to be transferred? Property, savings, checking. We also have a question from Karen. Art, can art be put in trust?
Yes, all of that can and should be put into a trust if you've created a trust. It does depend on what type of trust we created and why we created that trust. But all assets could go into a trust. We have clients with expensive artwork, but we would have to, with specificity, transfer that piece of artwork into a trust. How do we do it? With an assignment form. I hereby transfer my Picasso, wouldn't that be nice, into my living trust, dated so-and-so, date, etc. So as long as we do it with specificity, you can do it. It would be real property, your brokerage account, your Apple stock, or whatever it might be.
Terrific. Matthew wants to know, this is interesting, are there ongoing fees or paperwork associated with the trust? And does the trust need to file income taxes annually?
Okay. A trust typically does not file income taxes, but it depends on how we create the trust. The trust tax rate is very high, So we typically don't have the trust retain income. So if income goes back to you, let's say you're the grantor, then you pay the income on those assets. Depending how we set up the trust may or may not need a tax ID number, and will likely just have a K1. The trust had $12,000 of income in a year, gave out $12,000 to you. You pay the taxes on it. Not much work to do for the accountant on that trust.
Okay, thank you so much. I'm going to ask one more question because I know, we could ask a million questions, but I want to make sure that we respect everyone's time.
Sure.
Linda wanted to know, if you're not named as a distributee, even though you're a child of the deceased, will you receive a notification when the will is probated?
Okay, if you're a child, you are a distributee, which means if there were no will, you would get. So de facto, a spouse and or a child must get a notice of probate. Otherwise, that will isn't probated.
Okay, terrific. This was obviously, there are so many questions about trusts and wills, and they're so interconnected. And we will share, Ron, your contact information so that people can get in touch with you and be able to ask you and your associates specific questions. One last thing I did want to ask you, if you can give people a sense, because a bunch of people ask this, what is the average, how much should someone expect to pay to put together a will and a trust?
It depends on the type of trust. Typically, it could even be up to $5,000, but the way we put it to our clients, it's not a small amount of money, but it's a once in a lifetime fee, and that's what we do. And, you pay it once and you have it for the rest of your life.
Terrific. Thank you. Well, you certainly outlined why it's so important to have a trust and why it's so important to think about these things and all the potential scenarios that could be the case when you pass.
Absolutely.
All of this really protects you and protects your family. So thank you so much. This has been incredibly informative, and I really appreciate your being here with us.
Thank you so much. Thank you to AARP, and thank you, as always, to Schneps Media. You guys both are just unbelievable.
No, thank you.
Amazing organizations. Thank you.
Thank you so much. I want to welcome Antonio. Speaking of AARP, I want to welcome Antonio Coppola back from AARP. Again, he's the Associate State Director of New York City, for some closing remarks.
Thank you, Elizabeth, and thank you again, Ron. That was very, very informative. And I want to thank all of you for participating in what was the last of a 3-part webinar series on financial wellness, hosted by Schneps Media and sponsored by AARP New York. Again, my name is Antonio Coppola. I'm the Associate State Director at AARP New York. At AARP, we know that communities around the world are facing some of the most challenging times and generations. AARP is working to ensure that you have the financial security you need to take charge of your future and live independently as you age. We're focusing on supporting the communities throughout the state with opportunities to connect without ever leaving the home. We're offering many ways to keep you engaged and informed online. So connect with AARP New York at aarp.org/nearyou to learn more about at-home activities, wellness classes, upcoming events, and volunteer opportunities in your area. Or find us on Facebook at facebook.com/AARPNY to participate in free conversations with local and state leaders who talk about issues such as health, finances, or scams that are happening in your area. Thank you again so much for being with us here today. Happy holidays.
And please do stay with us for just one moment. I want to share with you a wonderful video. So just bear with us for just one moment and enjoy.
Hey!
Hey!
Hi! It's time to crack an egg.
Easy, any style egg works.
Or smile.
Well done, this looks great.
Time to share a story.
I have a great way to start our discussion.
With old friends or new ones.
When you're a caregiver.
Time to breathe in.
And count up. Good job.
Then let it all out.
Rah!
It's never been easier to connect, learn, and have fun.
Cheers.
So let's do it together. Come find us at aarp.org/near you.
Thank you again so much for joining us. Thank you again to AARP New York for sponsoring this very important and three-part series. Again, you can visit Schnepp's Media YouTube channel to be able to see the videos of all three of these very important webinars led by Ronald Fatoullah and Associates. And we will also be sending you information about how you can get in touch with AARP as well as with Ron Fatoullah. Please do visit the Facebook page for AARP. It's facebook.com/AARPNY and also facebook.com/AARP Long Island. Have a wonderful day. Happy holidays. Stay healthy, stay safe, and we'll see you at our next webinar. Bye-bye.
Happy holiday.